Welcome to Ask an Attorney, Florida Elder Law and Medicaid Planning.
Welcome to Ask an Attorney, Florida Elder Law and Medicaid Planning with John Frazier of Pippin Law Group, PLLC. John Frazier is a Florida Elder Law and Medicaid attorney based in Largo with advanced degrees in business and tax law and experience helping more than 3,500 families secure long-term care coverage. His practice focuses on almost exclusively on protecting assets and helping clients qualify for Medicaid benefits the right way. I'm Evan Mack, and today we're talking about what counts as an asset for Medicaid in Florida and what doesn't. John, welcome back, sir.
Good morning, and thank you for having me.
Good morning, John. So to start, can you kind of explain how Florida Medicaid defines an asset when someone applies for long-term care coverage?
I think the typical definition of an asset applies real estate, bank accounts, stocks, bonds, annuities. And I think the issue is whether or not those assets are exempt for Medicaid purposes.
What are the most common types of assets that are counted towards Medicaid eligibility?
Bank accounts, stocks, bonds, some life insurance, and then there's asset limits for those. So if you've got an unmarried person, there's a $2,000 asset limit. If you've got a married person with one spouse in the community, the spouse applying for Medicaid has a $2,000 asset limit, and the spouse in the community has an asset limit of $162,660. If both spouses are applying, there's a $3,000 asset limit for both spouses.
Which assets are typically not counted, even though many people assume they would be?
The Florida homestead is exempt up to $752,000. So my typical client, the house is going to be exempt. If a spouse is living there, there's no value limit on the homestead. One car of any value is exempt. Life insurance with no cash value is exempt. Funeral service or cremation contracts that are made irrevocable are also exempt.
Okay, so how are the retirement accounts like the IRAs or the 401ks treated when someone applies for Medicaid?
Here in Florida, we can make retirement accounts exempt. If we set up a systematic regular payment of all income plus some principal, the IRA or the retirement account will be exempt. Typically, the RMD payment, if that's being made, that is going to satisfy that criteria. In other states, IRAs are countable, and I had a Virginia attorney recently tell me that his clients have to liquidate and spend down retirement accounts first, and you can't make them exempt, according to the Virginia attorney in Virginia.
So, John, what happens when with a primary residence? When is a home protected and when can it become an issue?
It's going to be an exempt asset up to $752,000 regardless. In order for it to be an exempt homestead, the person has to have lived there for a certain period of time. And that's typically not a problem. But what that means is if someone is going to buy a house and they're already in a care facility, they must leave that care facility and then go live in that house for a certain period of time in order for it to be exempt, because the state of Florida requires an intent to return home in order for the property to be exempt.
How are jointly owned assets handled, especially when accounts are shared with a spouse or an adult child?
The general rule is that a jointly held asset is going to be treated as 100% of the Medicaid applicant. So a child can't add their name to an account and then say, it's now 50% mine. So the Florida Department of Children and Families takes that position on assets, on jointly held assets.
So, John, with things like life insurance policies or annuities, what details determine whether they end up counting towards that asset limit?
As I had mentioned, life insurance with no cash value is going to be exempt. So that's going to be the typical group or term policy. The other criteria is if it has cash value, each spouse is allowed to have up to $2,500 in face amount of life insurance, and then the cash value is disregarded. So, for example, if the Medicaid applicant has a $2,000 face amount policy with a $10,000 cash value, that's going to be exempt. On the other hand, if it's got a $3,000 face amount and a $5,000 cash value, that's going to be a countable asset. So we have to look at the face amount to see whether or not it's going to be an exempt policy.
So, John, can you share an example of a situation where someone misunderstood how their assets would be treated and it affected their eligibility?
Oh, yes, I think some people are, or perhaps most people are aware of a $2,000 asset limit. So we've had situations where a family member will quickly transfer all of the financial assets to someone else, perhaps that person or another person, a child, and that's going to create a disqualification period. I did have a situation once many, many years ago where we did the intake. The person had a very limited number of assets, and the reason for that was there was a multi-$100,000 transfer a few weeks before we were contacted. The family indicated that that money was no longer available to be returned to the Medicaid applicant. So we were not able to accept that case because that was too much money to give away in order to qualify for Medicaid without returning that money.
So, John, to kind of wrap things up, when someone is close to an asset limit, what usually creates problems in getting approved, that they didn't see coming?
Well, I think finding extra assets can be a definite problem. Over the years, we've had a number of situations where we find life insurance policies after we're hired. And so if we find 10 life insurance policies, all with face amount and cash value, that's definitely a potential problem. So I think just not knowing about all the assets up front is probably the biggest problem that we see.
Good stuff, John. Thank you for your time.
Okay, thank you for having me.
That's it for today's episode of Ask an Attorney, Florida Elder Law and Medicaid Planning. If you have questions about protecting your assets while qualifying for Medicaid in Florida, you can visit estatelegalplanning.com to explore free resources and schedule a consultation with John. Thanks for listening, and don't forget to like, subscribe, and share this episode with someone who might need it. And we'll see you all next time.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.